Hi, it's Kate Hawkins here again, a Principal Associate in the Advertising Law team at Gowling WLG. Another topic that I discussed during our recent ad law seminar was online choice architecture and the regulation of pressure selling techniques in an online environment, such as countdown timers and act fast messaging, or dark patterns, as they're sometimes called. I also touched on free trials and subscriptions, online reviews, and what's planned in this space looking forward. So starting with pressure selling techniques. This is a hot topic for the Competition and Markets Authority at the moment. They've launched a new program focusing on how businesses present information and choices to consumers online. As part of this, they launched the Online Rip-Off Tip-Off consumer education campaign, which prompted consumers to report sneaky online sales tactics and provided tips on how to spot and avoid these. Last year, the CMA published an open letter to businesses that sell or advertise online, reminding them of their obligations under the consumer protection legislation when it comes to urgency and price reduction claims. The key takeaway being that businesses should not use these tactics where they are misleading, untrue, or put pressure on consumers. The CMA also concluded its investigation into Emma Sleep's online selling practices last year. The CMA has confirmed that the fact that the Advertising Standards Authority upheld complaints about Emma Mattress in 2022 was a factor in the CMA picking them as a target for enforcement action. So this is a good reminder that ASA rulings matter, and it's a big mistake to think that they don't. All right. So getting into the specifics of Emma Sleep's claims that prompted the CMA action, their website featured extensive discount offers, like the Was Now pricing you can see on this slide. During its investigation, the CMA found evidence that only a small fraction of Emma Sleep products were actually sold at the full price. That meant that claims, like these ones, were giving consumers the false impression that they were getting a better deal than was the case. If Emma Sleep had actually sold the mattresses for the crossed out Was price for a longer period of time than a promotional price and in significant numbers, then the promotional price claim would not have been misleading. But that wasn't the case here. Here are some examples from the CMA's open letter that I also ran through during our seminar. The CMA is concerned with brands flip-flopping between promotional prices and their usual selling price. Alternating prices without resting the product at the higher price is problematic. You can't say that the higher price is the usual selling price when it's available for the same length of time as the lower promotional price. So you should take care when planning your promotional calendar, as basing a savings claim on a higher price in those kinds of circumstances will likely be misleading. Back to the CMA's investigation into Emma Sleep. The advertiser was using countdown clocks like the one shown here. With my consumer hat on, I would assume that once the timer runs out, the product will return to its higher price, right? Not so much here. The problem was, once the timer ran out, the clock was replaced by another. The CMA found that timers like these can put pressure on shoppers to buy quickly out of fear that they'll miss the on-sale price. This can lead to rushed purchases in order to grab a perceived bargain, which will be in breach of consumer protection laws. The CMA is also concerned with popularity claims like, hurry, 10 people are viewing this item right now, or 10 people have bought this item today. These can be unlawful where they are not based on accurate data or do not make it clear what time frame they are based on. So for example, 10 people might be viewing the item or hotel room or other deal, but not right now. 10 people might have bought the item, but not in the last 2 hours. It might have been looking at the data from the day before. Claiming that there is a lot of interest in a product and prompting consumers to buy the product quickly will be misleading if there is no need for consumers to hurry. Scarcity claims, like the one on this slide, imply that stock levels are low so that consumers act urgently and sometimes impulsively to buy an item quickly in order to avoid missing out. These tactics will be unlawful where stock levels are not as low as claimed, or at least high enough to mean that a brand can fulfill expected orders for a day or expecting more stock to arrive shortly. It's also worth flagging that these techniques aren't just restricted to retail products. It may be that businesses are using these kind of messages in other sectors, like travel and property. For example, claims might be made that there is only one more room left in a hotel for a certain price, or that there are only a certain number of flats available in a development. If this is not genuine and is designed purely to prompt people to act with urgency, then it will likely fall on the wrong side of the rules. Another key development in online advertising concerns subscription traps. This is a hot topic for UK regulators, particularly given research that 1 in 4 people have signed up to a subscription service by accident, mostly because they didn't get around to cancelling a free trial. The ASA published new guidance and an enforcement notice on this topic last year. The ASA will expect, as for a free trial or other promotional subscription offers, to make clear all of the significant conditions likely to affect a consumer's decision to participate. Including a token T's and C's apply will not be enough. Rather, you need to make it clear whether a paid subscription starts automatically after the free trial, unless cancelled, the extent of the financial commitment if the subscription is not cancelled during that trial, and any other significant conditions, such as the cost to participate. The ASA considered free trials and subscriptions when Instagram ads for On That Ass were complained about last year. The ads looked similar to what I've got up on the slide and include the claim, "Try now for free." The ads linked consumers to the brand's website, which stated, "Always the perfect pair of boxer shorts. Receive awesome boxer shorts every month," followed by checklists that included the claim, "No strings attached, always cancelable online." The ASA concluded that consumers would understand the claim, "Try now for free," to mean they would receive a free sample of boxer shorts and wouldn't expect to sign up to a free trial for a subscription service in order to receive the product. Because the ads didn't include any information relating to the free trial period or make it clear that in order to receive the free product, consumers needed to sign up to the subscription, the ad was found to be in breach of the advertising code rules. Some final thoughts now on subscription traps before we move on to online reviews. The ASA has made it clear that it will take targeted enforcement action to ensure non-compliant ads for free trials or promotional subscription models are amended or removed, helping to secure a more level playing field. This is a clear signal that the ASA will specifically and proactively target advertisers of subscription services. Plus, the proposed Digital Markets Competition and Consumers Bill introduces tighter controls over the advertising and provision of subscriptions, which aligns with the ASA's approach. Under the DMCC bill, businesses will need to provide clear information to consumers before they enter into a subscription contract, remind consumers before a free trial or introductory offer comes to an end or that contract auto-renews onto a new term, and allow consumers to enter a subscription contract easily. Even if you don't think that your organisation has an explicit subscription offering, it's worth double-checking your advertising and website copy, particularly given the CMA will be able to take direct enforcement action against businesses in breach of the new rules. Of course, this all applies to your obvious examples like On That Ass, or where consumers in a subscription-based membership to access exclusive holiday homes, for example, but also to less obvious scenarios, such as where access to infotainment and other connected car features is only available on a subscription basis. Now for fake reviews. Given their influence, it's essential that online reviews are authentic. Fake reviews can distort purchasing decisions, leading to consumers choosing poorer quality products and making it difficult for businesses to operate on a level playing field. With all of that in mind, it's no surprise that this is another area that both the ASA and the CMA are keen to tackle. Nothing much has changed when it comes to the ASA's policy. You need to make sure that reviews are accurate and genuine and reflect what the person said. You should also make sure that the review is relevant to the product or the service that it is being used in connection with. Encouraging consumers to leave a positive review, for example, in order to enter a promotion, might breach the advertising rules if that review does not reflect their genuine opinion. On the other hand, deleting negative reviews may be misleading if it doesn't then give a true reflection of the overall consumer experience. Reviews should also comply with the advertising code rules more generally. For example, they shouldn't include claims that would otherwise breach these rules. Turning now to the CMA. The government is consulting on whether they include fake reviews to the list of banned practices in the consumer protection legislation. For context, the DMCC bill repeals and reinstates the Consumer Protection from Unfair Trading regulations. As many of you will know, a list of banned practices is included as Schedule 1 to these regulations. These have largely been carried over into the new bill as Schedule 19. While this list doesn't refer to fake reviews at the moment, the government will be empowered to update the list of banned practices to best reflect new online practices and emerging consumer harms. The ASA has now launched a consultation seeking views on adding banned practices relating to fake reviews into the list, as summarised on screen. This would mean that any business that publishes or provides access to reviews has a responsibility to ensure that consumers are not misled by them. We doubt you would be subject to enforcement action on the basis that you publish a single fake review, but you will likely need to have policies and processes in place to regularly and proactively assess the risk, look out for suspicious reviews, remove those, and sanction those involved. The consultation is live now and waiting to see the results in the government's report and how they plan on finalising the DMCC bill. Now for some horizon scanning. We expect to see more and more scrutiny of online choice architecture and continued efforts to bolster consumer understanding of various online sales tactics through CMA crackdowns, beyond Emma Sleep and Woucher, and proactive ASA investigations. We have the implementation of the DMCC bill to look forward to this year, which is intended to reform the law on unfair commercial practices, as well as combat subscription traps and fake reviews. With the increased powers being granted to the CMA, most notably the ability to fine businesses directly, we're likely to see brands reevaluating and revising their advertising to avoid more serious sanctions. If you would like to talk through any of this in more detail with us, or if you have a separate advertising law query, then please do reach out to myself, Dan Smith, or Zoe Pearman.